person's not watching.
Like a surprise punch.
Exactly. You know the guy that I hit in the back? I committed battery, no doubt. But because I never put them in apprehension that I was going to hit them before I hit them, I did not commit assault. So when either the negligence or the battery is used in malpractice, oftentimes there is no assault element. Okay? Because the patient knows what you're going to do, but they're not apprehending the moment that you're going to do it. Yes?
So if you make like an assault, okay, let's say something like, I put your gun in your face, say like, give me your money. So that's an assault, right?
That's an assault.
So, and if I like shot the gun or something, so it's gonna be like 2 crimes?
Absolutely. Absolutely. Assault and battery are 2 crimes or 2 torts. Assault and battery are 2 crimes and 2 torts. Now, can you get away with hitting somebody in the face in the middle of public and not go to jail? How?
You did talking.
I did, but can you get away and be authorized to hit somebody in the face
No.
and get away with it? You say no, right? But you know and I know that you can't.
You can still hit it, but if
Have-
you're not charged,
you play
then
soccer?
you're-
Have you ever been kicked?
Yeah.
Have you ever been kicked intentionally by another player?
Yeah, sure.
Okay, did they go to jail?
No.
Did you sue them? Okay. Battery, that's authorized. What I'm trying to get at is that sometimes the recipient authorizes what you and I would consider to be wrongful conduct. In sports, there is behavior that is accepted. In hockey, people punch you in the face and guess what? That's part of the game. It's part of the game. MMA, right? In MMA, you kind of knock the person's teeth and they laugh at you and they hug you and kiss you at the end, right? Isn't that weird when 2 boxers have been hitting each other for 16 rounds and at the end they give each other a hug and a kiss?
Yeah,
Kind of weird. But at the same time, it's authorized conduct, and that's where I want to go. When you have wrongful conduct, you have to examine whether the conduct was authorized. Let's take hockey for a second because there's a famous case. In hockey, what is the, other than the ice and the skates, what is the major difference between hockey and soccer? Yes? The stick. Well, the puck takes the place of the ball. But in essence, the objective is the same. Okay. Now, there is more roughery that is accepted in hockey than in soccer. You don't have, except for that Mundial where the guy headbutted the other player in the, right? Because he said something about his mother or his wife or somebody. Remember that one? It's not accepted. And what happened to him? In hockey, when you punch somebody in the face, what happens to you? They send you to a penalty thing, which is kind of timeout, like for little kids. And then after a few minutes, you come back out. And it's no big deal. I punched you in the face, let's go play. But there's a famous case where a hockey player grabbed a stick and hit another player over the back of the head with the stick. Now, we understand that certain amount of contact and certain amount of violent contact is authorized. But in sports and battery and torch, you have to ask the question, what is accepted and what is not accepted? And that particular player was arrested.
Of course.
Yes.
You can
Yeah,
kill it.
like it depends. Like if the tackles and like the punches are like dangerous, but like if they're fighting, like going up against each other, like boxing. Because I used to play hockey as well. Like then it's okay. Like the
Because
Yeah.
it's part of the game, you've authorized it. But what you have not authorized is that guy to come with the stick over your head and chop
Yeah.
you. Yes.
Because the players know that was against the rules and he did anyways.
Well, fighting is against the rules anyway, but it's acceptable conduct of that particular sport. By the way, it's not acceptable. Fighting is not acceptable in the European style game. It's a lot faster, a lot cleaner. There's a lot more fighting that takes place here. But the point that I'm trying to make is that you have to look at the behavior and ask yourself, was this behavior acceptable? Did the person that was the subject of the violence authorized the behavior somehow? If the answer is yes, that by participating in this game, you authorize the behavior, it's not actionable. In boxing, people have died in boxing matches. And there's no cause of action that can take place in a boxing match by the family of somebody that has died because the other person punched them in the head, because it's authorized behavior. It is when the behavior becomes outside of what is accepted or what is expected that the behavior then is punished, and what's accepted and expected changes over time. In hockey, it's not authorized to punch somebody in the face. It's against the rules. You get to be put time out. But you can't file a lawsuit because over time, that behavior has been, even though it's unlawful, has been accepted. In football, targeting, that is, or hitting a receiver that's unprotected, I have no idea what that is, but if you hit a receiver that's unprotected, you're going to get kicked out of the game. That receiver might be paralyzed. That receiver may have a concussion, but you cannot be sued because even though it's against the rules, it's acceptable within the things that are outside of the rules. So the conduct has to be so far outside of the rules that you can say from the outside that person should be punished for that behavior. A number of years ago, for example, a number of basketball players, going into basketball since it's your arena, were involved in a fight. Have you ever heard anybody involved in a fight in a basketball game go to jail? Well, in this case, they did. Well, they were arrested. Why? Because they went into a fight into the stand with observers. Accepted in here, not accepted out there. Okay? Negligent behavior. In baseball, when you're sitting along the field, if a ball is hit and a bat breaks and hits you in the head, can you sue them for negligence? They didn't build the bat correctly. And the answer is no, because being a fan doesn't absolve you from behavior that you accept. And that is, if you get hit with a bat that's broken in a baseball game, guess what? It was acceptable behavior when you bought that entrance. You knew that that could happen. It doesn't happen every day, but you knew that that could happen. So, in torts, in order for the tort to be a cause of action, you not only have to look at the action, you also have to look at the behavior of the individual that has been involved in the tort to determine whether there is some authorization for that behavior. Now, let me ask you this. Oftentimes down the expressway, two cars are doing something unlawful. They're going at, terrible speed, and they have an accident. One individual is more injured than the other. Can that person sue the other one? Say, I know I was negligent, but you were more negligent. Can you sue the other one? You say no. Why not? You were injured.
Well, yeah, you can.
I was just luckier. I didn't get as injured as you.
Yeah, you can.
Why can you sue me?
He's being reckless. He's being reckless.
Oh, so were you.
Of course, I'm being reckless. I take my part, but.
But why can you sue them if you were reckless too?
Oh, well, then don't sue no one.
So I convinced you to back off.
Then don't sue no one. Then.
I convinced you to, but you're injured. You've got damages.
Well, but it's your own fault too, because you have
So
to.
you say no way, Jose, you can't.
If it is my fault, not his fault.
What if you're violating the law
Oh, well,
and
that's
you're
my fault.
injured?
Well,
Let's
that's my
say
fault,
that you're driving
100%.
down the expressway and you're not wearing your seatbelt and somebody hits you and you get injured, and that injury could have been to a certain extent alleviated by the fact that you were wearing your seatbelt. Can you sue me for
Well, if
injuring
you
me?
hit me, yeah.
Well, you weren't wearing your
They
seatbelt.
put me a ticket for not wearing it.
Well, I was the guy that hit you. I don't have the power to give you a ticket. Can you sue me?
The cops, when they come, they'll give me a ticket.
Okay, you get a
but I
ticket,
won't
so that's-
sue you for
So you would sue
crashing.
me?
Of course.
But you
You
were,
crashed me.
but I know,
I don't
but
have
you were
the signal, that's
responsible,
my
you didn't have your,
responsibility.
No,
Right?
I'm a-
But you
so
still
why should I
crashed
pay
my
for your
car.
damages? Why should I pay for your damages? You weren't responsible.
But you crashed my car.
Yeah.
I
So
did.
of course you pay my car.
So I should only pay for your car, not for
Exactly,
your injuries.
not for me, because that's my own fault.
Do you all agree with that?
Yeah, I agree with you.
Okay. The answer is the law has the same feelings and instincts that you do. The law says so, or it used to say this. It says, look, when two people are negligent together, and that negligence leads to injuries, we're not going to allow anybody to recover. Okay? That was the defense of contributory negligence. You contributed to the accident, you contributed to the negligence, and therefore, we're not going to let you recover. But that becomes unfair because sometimes you say, this person was really, really, really negligent. They were speeding, they were racing on the highway, and all I was doing in my contributions, I wasn't wearing my seatbelt, and the law said it didn't matter, as long as you were a little bit negligent, you couldn't recover. That's it. And that was appropriate because it was very difficult, medically and otherwise, to discern what your negligence contributed to and what my negligence contributed to. So, courts didn't want to say you were 1% negligent and you were 99% negligent. It said any negligence anywhere prohibits. But people began to use that word this is unfair. It's unfair. My negligence was little and yours was a lot. I've been injured a lot and I can't recover. It's unfair. So courts began to listen to this, it's unfair. And they began to say, you know, it doesn't make any sense. That you were just not wearing your seatbelt and this person's racing down the street, he's wheezing in and out, he's going 150 miles an hour, he hits you and the law doesn't allow you to recover. That's unfair. So, courts today utilize a concept of contributory negligence. What does that mean? What it means is this. When you go to trial, one party has to prove negligence. What the court says is this. We have this group of people called a jury, and we're going to allow them not only to determine the negligence of both sides, we're going to have the jury determine this is the negligence that caused the accident. The jury today determines the contribution of both sides. At the very end, the jury says this. There was negligence. Both of you were negligent. The amount of damages that you suffered was, let's say, $100. Your negligence contributed to your injuries of $100 by 10%. So this is the amount of money that you've been damaged. Your contribution to your damages is 10%. So how much money do you get? You already had the 10 that you're responsible for, and therefore, today the concept of contributory negligence basically does this. The jury determines the negligence of both sides. The jury determines the amount of injury and then subtracts from the whole the amount of your contribution, the percentage of your contribution, and therefore this is what you recover. Is that a fairer system? Absolutely. You don't recover everything because you were negligent too. But you do recover the amount that the other person was negligent for. That's the concept of contributory negligence. Okay? And we see a lot of contributory negligence in business cases. How do we see them? Well, imagine that you are driving a product and you receive in the mail a notice that there's a recall of your car. And you look at it and you still drive it around. Hey, it's not going to affect me. You know, I don't have time to leave my car at the shop. And you continue and you have an accident. Okay. Then you sue Ford Motors or whoever the manufacturer is for that, and they're gonna say, hey, wait a second.
You can't. They already give you a warning.
We gave you a warning, so the question the jury has to answer is,